Hi everyone, we are starting a new series of videos, of which there will be 4 in this new bonanza, on pre-termination negotiations. So these are discussions which take place between employer and employee with a view to achieving some sort of agreed settlement on confidential terms. This specifically relates to a section that was added into the Employment Rights Act 12 years ago, section 111A. And it essentially creates a framework for having what in many cases will remain a confidential discussion around alternative outcomes aimed at preventing long drawn out processes with a view to reaching dismissal. Prior to this section coming into the Employment Rights Act, we did have a more traditional without prejudice rule. We're not exploring that on this series of videos, and we're also not going into the drafting of a formal settlement agreement. What we are talking about is the mechanism for having this discussion, ways in which the discussion should be held, and risks associated with those discussions, and when the protection of confidentiality may be lost. So to start with, we're just setting the framework for the discussions themselves. And when we look at section 111A and when we reference pre-termination negotiations, we mean any offer made or discussions held before the termination of employment with a view to it being terminated on terms agreed between the employer and employee. And what we have from the conciliatory body ACAS is 2 documents: one code of practice on settlement agreements, which will be taken into account by tribunals if talks break down and they are asked to judge on the fairness or confidentiality of a procedure, and also supplementary guidance on settlement agreements. So we get some pointers in terms of how to act here, because the legislation is not particularly detailed. So when we're looking at how to actually have a discussion with an employee of this nature, the Code of Practice on Settlement Agreements very helpfully says that how the proposal can be made varies depending on the circumstances. So the reasons for the proposal should be given when it is made, and that might be the company is looking at a potential redundancy exercise or a performance management discussion, and what we want to do is have an alternative discussion to see whether another resolution can be reached. The proposal may be given verbally, but it should be confirmed in writing, and ultimately a settlement agreement would need to be put in place to formally record the terms of an employee's exit. Parties should be given a reasonable time to consider the agreement, and again, what is reasonable depends on the circumstances of the case. Code of Practice does refer to 10 working days, which I think is quite excessive in circumstances where often these discussions arise where businesses need to make decisions, and in reality I don't see many discussions where that time frame is given, but that is what is stated in the Code of Practice. The employee should receive independent advice on the terms of an offer, and especially if that goes into a settlement agreement, that is a mandatory step which would prevent the employee from bringing claims against the employer. And whilst it's not a legal requirement, the Code of Practice does recommend that an employee is allowed to bring a legal representative in with them to any potential settlement discussion. Again, I'm not so sure I agree with that. That's a very good step practically, and we do explore that in the next video. If we then look at the settlement agreement guidance that's supplementary to the code, this suggests that whoever is making the offer should be prepared to answer questions that may follow in any discussion. There may be a series of meetings to discuss settlement and try and drive that through. The employee should be permitted to make a counter offer if they wish to do so. It talks about the setting of the scene essentially at the start of the meeting, so making it clear what that meeting is about, and making it clear as well that any such discussions remain confidential and are not admissible in any future tribunal proceedings. And in a future video we'll come on to what we mean by that and where there are some exceptions. And importantly as well, it should be made clear that the outcome of these discussions and whether the employee accepts or not will not have a bearing on any future process which is adopted. We go on to improper behaviour in future videos, and it's important that this is not seen as a threat or an ultimatum, but a genuine choice for the employee to make. So this is the introductory video on setting the scene. In the next video we'll move on to the time taken to consider offers and the role of a potential representative before looking at admissibility and improper behaviour. If you do need any support on this issue, please do get in touch. Visit the website chadwicklawrence.co.uk or email employmenthub@chadlaw.co.uk. Thank you.